What happens with the house for unmarried couples? A lot of people have the misconception that there is a common law marriage, and that isn't the case. Unfortunately, there's no rights when you aren't married, unlike when you are married. A lot of people purchase a house together and they don't get legal advice when they do that. Sometimes there's situations where couples buy together but one person contributes more than the other. Another situation could be where one person buys the house because the other has had historical bad credit. There's several situations that might arise, and we would recommend that you get legal advice at every step. When you purchase a property, you should be advised how that's going to be held in the title deeds with Land Registry. If you have contributed more towards the deposit, for example, you might want to protect that. You can do that by holding the property as tenants in common, and then you can have a trust deed drawn up that would reflect the deposit that you've paid, or you can have a declaration of trust within the title deeds. If you have contributed more than the other person, then you might want to record that in the title deeds. You can do that also in a declaration of trust. This should be explained to you by your solicitor. However, quite often when you first buy a house or move in with your partner, you're not always thinking about the contributions that you might make throughout the relationship. And then ultimately, if you do unfortunately separate, then you might not have any entitlement to that share of that property. We always recommend that if you do start living together, then you could enter into a cohabitation agreement. This would record any interest that you have, and you could then refer back to that if you do unfortunately separate. The best way to protect your interest in the property is to have a declaration of trust, which could record an unequal share, or you can have a trust deed drawn up, which would be registered at Land Registry. And you can, for example, have in the trust deed the deposit that you might have contributed or that your partner has contributed. I often come across situations where one person moves in with their partner and the partner has owned that property for sometimes a considerable amount of time before they start cohabiting. In this situation, the person that owns the house would understandably want to protect the money that they've paid for the deposit and the mortgage payments that they've made. However, not everyone considers when they do move in with that partner, if you do come to separate, for example, 30 years later, and you have contributed for a significant amount of time, you could have potentially helped pay off the mortgage. If you don't protect your interest in a trust deed, then you could end up with nothing. There are circumstances where you could potentially say that you have made a detrimental reliance on that person's promise. For example, if they promise to pay you half of the equity, but that doesn't always stand up in court, and the best way is to have a trust deed drawn up. It is best to try and have a chat with your partner about this, and you could have a chat with us and see if we can help you in any way. If you'd like to arrange an appointment, just drop us an email or give us a call. Thank you.